Hello, I'm Bev Jackson, co-founder of LGB Alliance, and I'm here with my fellow trustee, Professor Rob Wintemute. Professor Wintemute is one of the UK's leading experts in human rights law. He has an international background. He gained his law degrees in Canada, practiced law in the United States, and gained his doctorate from the University of Oxford. Since 1991, he has taught at the Law School of King's College, London. His main interests are human rights law, anti-discrimination law, European Union law, and sexual orientation and the law. He's published extensively on these subjects. He's also represented applicants and third parties in numerous lesbian and gay rights cases before the European Court of Human Rights in Strasbourg. It goes without saying that we are very fortunate at LGB Alliance to have perhaps the foremost expert on sexual orientation and the law as one of our trustees. It has been particularly important in the area of same-sex couples and occupational pensions, the right of a same-sex partner to the occupational pension of their partner after their death, especially after Brexit. When we announced the great news of our win for same-sex couples a few days ago, we knew it was a complex area that many people would find hard to understand. So we thought it a good idea to invite Professor Wintemute to explain the problem and the solution that he and the other trustees of LGB Alliance managed to achieve. As expected, the gutter press managed to get completely the wrong end of the stick, and there will be notes accompanying this video for people wanting to look up any of the things that we mention. So welcome, Rob, and thank you so much for giving us your time today. Thank you.
Thank you.
Well, perhaps you could start with the root of the problem in the Equality Act 2010. What is this nasty discriminatory exception they put into it?
Okay, actually it goes back to 2005, before the Equality Act. So at that time, there were regulations were made to prohibit sexual orientation discrimination in employment, but benefits related to marital status were excluded entirely, because at that time all same-sex couples were unmarried cohabiting couples. There was no way to register your relationship. So in 2005, we're approaching the 5th of December when the Civil Partnership Act 2004 is going to come into force. So this exception was introduced, saying basically you could claim discrimination with regard to employment benefits as a civil partner, comparing yourself with a spouse, so same-sex civil partner, opposite-sex spouse, but this would not apply to any benefits relating to employment before the 5th of December 2005. So this was a fear of financial catastrophe for pension schemes. They must have lobbied the government and said, we never foresaw that all these unmarried lesbians and gays would suddenly be going to the town hall and getting legal relationships. And this is not in our financial planning. It's catastrophe for us. We'll all go bankrupt. So they insisted on this exception was written in, which had catastrophic consequences depending on your age. So let's say you're 25 years old on the 5th of December 2005, you're just starting a new job, you've just joined a pension plan. 40 years later, you will retire with full benefits. This law would not affect you at all. But in someone in John Walker's position, he had retired in 2003. He worked for a private company, and they were not generous like public sector pension schemes, which generally decided we will not rely on this exception, and we will generally treat same-sex couples equally. So this private company said, well, no, that's the law. The law's on our side here. You made all of your contributions to the pension scheme before 2005. Therefore, they do not count. If you die before your civil partner, he will get nothing or almost.
So can I just interrupt you for a second, Rob, because
Yes,
you said
yes.
it started back in 2005,
Yeah.
but the discriminatory exception was then incorporated into the Equality Act.
Yes,
So it was a real inequality, a discriminatory provision
Well,
was
see what,
stuck
and
into the Equality Act.
Now, to be fair to the UK government, in 2005, they thought they were allowed to do this under EU law. But in 2008, the Court of Justice of the European ruled in a case called Maruko from Germany that this was not allowed, that you had to treat registered or same-sex registered partners in the same way as opposite-sex spouses with regard to survivors' pensions.
So when we come to John Walker, as you say, he retired in 2003. And so because of this discriminatory provision in the Equality Act, if he were to die, then his occupational pension, the rights, his partner wouldn't have the right. Is that correct? They wouldn't have the right to it because it was all before December 2005. Is that right?
Yes, as I recall, his company said your civil partner will get some kind of nominal amount of £500, whereas if you leave him, go through a dissolution and marry a woman, she will get over £40,000 a year.
£40,000 difference, and so that's the kind of money we're talking about. This discrimination can lead to. So what happened in 2017 with this case, this very important case, the Walker case that you've been referring to?
Okay, well, as I mentioned, the UK government was put on notice in 2008 by the Court of Justice, could have changed the law then, but instead incorporated the exception into the Equality Act. At the time, in 2010, I did not even know about this exception. I didn't even know about the 2005 version. I only heard about it while working on the Equal Love campaign with Peter Tatchell. We were trying to get same-sex marriage and opposite-sex civil partnership. So, and the idea is what same-sex couples would have equal rights once we were allowed to marry. And suddenly we began hearing from retired people facing discrimination from their pension, on the part of their pension schemes. I didn't know about this at all. In fact, when the Maruko judgment came out in 2008, I thought, well, that doesn't apply to the UK. We don't discriminate with regard to pension. So we started hearing about these cases, and I referred at least one of them to Liberty. And Liberty eventually took on John Walker's case. And so it went into the courts, and he lost in the Court of Appeal by 3-0. And I wrote comments, I published comments before and after the Court of Appeal's judgment. And it went on to the Supreme Court in 2017, and he won by 5-0.
Now, as I understand it, the reason that he won there, and of course they looked to the Supreme Court, or the barristers, I think, arguing the case, relied to a significant extent on what you had written. So you played quite an important role there before the Supreme Court. But as I understand it, the point was that this kind of discrimination was against EU law, correct?
Well, that's what made the case so strong.
Yeah, it was against EU law, so that would only apply as long as we were still in the EU.
Yeah. So that's actually the John Walker relied on the Human Rights Act as well and EU law, but the Supreme Court said EU law is enough.
Right.
And and they referred to my 2014 comment and said I had explained the error in the Court of Appeal's reasoning. So it was quite a technical case, but we got there in the end. And what did they say? Now, a UK court has no power, or had no power under UK law to strike down an act of Parliament. So what they could do to give effect to EU law was say that this exception had to be disapplied. Sometimes people say it has to be set aside. Okay, so basically the exception became unenforceable as long as we remained in the EU.
So wait a minute, you're saying that the exception was still there, but by a kind of sort of, I don't know, verbal trick, they said, okay, we're not going to change the exception because maybe that was too much work. They were too busy doing other stuff. I don't know. But we won't change the exception, but we'll say you can't apply this discriminatory exception as long as the UK is still in the European Union. Is that right?
Yes, that's all the UK Supreme Court could do. And so what the UK government could have done in 2017 was immediately amend the exception. But they were much too busy with leaving the EU. So what they did is put a general provision in 2018 in the EU Withdrawal Act. Now, that provision is so vague that even an expert lawyer reading it would struggle to see, this is Section 4 of this Act, struggle to see how this preserves the Walker judgment. That was their intention, but I was in touch with John Walker. He told me that a minister had told him, don't worry, this is retained EU law, it will all be fine. And I looked at the 2018 Act and I couldn't follow it.
You couldn't follow it.
No.
So if you couldn't follow, so what you're saying is the Supreme Court had decided that this discrimination was against EU law, and all the UK government did was to then say, okay, we'll put this disapplication into the EU Withdrawal Act in such a funny way or such a general way that actually even you couldn't really follow it. You're saying that so it was a really weird solution.
Yeah,
it wasn't really much of a solution.
I mean, it said basically rights that exist if they've been recognized by a UK court will continue to exist.
Okay, well, nobody understands what that means, and which rights do and which rights don't.
And so what could have happened since 2017 is that a private company is faced with a surviving same-sex civil partner or spouse and says to them, well, our copy of the Equality Act says we're allowed to discriminate against you, and we're going to do it. Now, the surviving partner or spouse is not going to know about the 2018 Act or the Walker judgment or this complicated chain that makes the exception enforceable. So they may well have said, oh, that's a pity, I don't get a pension.
Do we know if any such cases actually happened, or was it was a lack of clarity that could have been exploited by an unscrupulous company?
It could have been exploited. Yeah, I don't know of any specific case.
Yeah. So anyway, but it was sort of resolved, but not very well. And then, but that act, that EU Withdrawal Act, with this sort of weird general provision that nobody can understand, that is due anyway to expire at the end of December. And last year, I think it was last year, that you became worried that with the new act that would come into effect, the retained EU law act that comes into effect, that the effect of the Walker judgment would be lost. Well, why did you start thinking that?
Well, it was the second I heard that Jacob Rees-Mogg was introducing a bill to abolish retained EU law. He thought this was a stain on the UK legal system and had to be removed, which, that was his preference. But I immediately was concerned about the Walker judgment, which was supposedly preserved by retained EU law. And that's when I began raising the issue. And this eventually led to a letter from LGB Alliance to Kemi Badenoch in January 2023.
Now, what you really wanted, I remember at the time, was you wanted this exception to be removed from the Equality Act because it's a blatant discriminatory provision. And you wanted a new bill. It was just a very tiny little bill, wasn't it? It was a couple of paragraphs you wanted passed. But I suppose the trouble with the bill is it needs to be discussed in both houses of Parliament. Somehow you didn't get much of a response to your when you kept presenting this bill. And I know that it wasn't just you. It was also we were bringing it to the attention of all sorts of officials in government through other trustees, such as the Labour peer Lord Young, and also especially I think co-founder Kate Harris was constantly trying to bring this to the attention of officials in government. It just didn't seem to be working, did it, for a long time?
Yes, and to be honest, I think that was and remains an insult to the LGB community in the UK and to same-sex couples.
Why do you say that?
Because they're saying you're not worth a few hours of parliamentary time. A bill would have solved the problem permanently, decisively. Instead, well, first of all, they said attach an amendment to the retained EU Law Act. It was a bill at the time. And what happened was in April, we were told that as we were trying to do that, in April, we were told, well, the bill's dead. And that was the newspaper report. And then May, it suddenly...
Sorry, which bill
the
was
retained
dead?
EU law, yeah. This is Jacob Rees-Mogg's project to get rid of retained EU law. And it takes the 2018 provision that preserves the Walker judgment and repeals it as of the 31st of December.
So that is that very vague provision, general provision that you couldn't understand anyway, which sort of solved the problem, but not very well. That was due to expire on the 31st of December. So then the Walker judgment is gone if that happens.
Yes, yes. So the proposal was we would just slip into the appendix or a schedule to this bill, repeal of the exception. And well, we proposed this to the government. They could have done it themselves, but they didn't.
Simply to repeal the exception.
Yeah.
And then the problem is gone. If they had repealed the exception. Yeah.
Would have been gone. They didn't do it. And by the time we heard the bill was back on in May, it became law within 2 weeks. There was no time to get anything done. So we went back to them and said, okay, now what? And I said, we need a bill. We need a bill dealing with this specific issue.
So you were still pressuring the government. You were writing to the government saying this exception is this discriminatory exception against same-sex couples, which was sort of solved before, is now in danger of coming back and actually, worse than before in a way. Yeah.
Well, yes. I mean, you could. If anyone who's seen the film Carrie, the ending, can imagine this exception rising from the dead and striking same-sex couples who are affected by it.
Yeah.
So yes,
but you were really persistent, weren't you? I remember you brought it up at every board meeting. This has got to be solved. This is looming over us. We have no idea whether they are going to allow this this pernicious exception. Well, the exception remains. And what if they now finally they have solved it, but in the most peculiar way? Well, how have they solved it?
Well, my last email to one government advisor got the response, well, we need to use powers under the retained EU Law Act to make regulations that will solve the problem. I replied and said, well, I've read the act and I don't think this power exists because you are trying to amend the Equality Act 2010 with regulations. And normally you can't amend an act of parliament except with another act of parliament, which means...
Well, what did they say? What did they say when you said that?
No reply.
Oh.
And we renewed correspondence with Kemi Badenoch's office in late October, early November. And then eventually we were told that magically regulations had appeared and been laid before Parliament.
And so what the regulations that have been laid before, which finally solves this problem, perhaps not in the way that you would have liked, but it does solve the problem, is an exception to the exception. Is that correct? This amendment that we managed to finally get taken on after all this pressure. What does this amendment actually say?
Well, there are two sets of regulations, one for Great Britain, one for Northern Ireland. And what they do is they both create an exception to the exception. The general exception is that discrimination against same-sex couples in relation to employment benefits is allowed in certain circumstances.
That's these circumstances being rights accrued before 2005.
Yes. Mm-hmm. And what the exception to the exception says is that the exception does not apply to occupational pension schemes.
Right, that's it. It doesn't apply to it. But I mean, it sounds like a small thing. And I know that you're not entirely happy with how this has gone and you would have liked it to be done differently. But the fact is, this can make a difference of tens of thousands of pounds to someone whose partner has an occupational pension, a substantial part of which was paid in before 2005, correct?
Oh, absolutely. And it resolves the uncertainty for John Walker and his now husband and other same-sex couples in the same position. So John Walker's company, after the Supreme Court judgment, was unlikely to have refused to pay the survivor's pension. But management can change. New management could come in saying we have to cut costs, and this exception is still in force, and therefore we're going to use it. So
now we have an exception saying, anyway, even though it hasn't been done in exactly the way we would have liked, it is now no longer possible to discriminate. From the 31st of December this year, it is absolutely impossible to discriminate against a same-sex couple in terms of their occupational pensions. And look, Rob, I just want to say I thank you for talking us through this. It's really a complicated area of law. We've seen Michael Ferrand has very kindly provided a thread explaining the main points to those people who seem to have either deliberately or unintentionally completely misunderstood. I'm just really grateful to you and to the rest of the trustees in particular. I think Kate Harris has been pushing so hard for this. And I'm just really proud to be part of LGB Alliance, because we stand for LGBT rights and we always will fight for the rights of people who are same-sex with same-sex sexual orientation to get the rights they deserve. And I just want to thank you for all the work you've done, Rob, and thank you for joining us today and explaining it.
Can I just say one last thing?
Oh, please.
It's not good enough. Okay, so yes, we could say the exception has been defanged, and it is unlikely to harm any same-sex couple. There's a theoretical possibility that something could slip through, but symbolically, it's still there, and it's insulting. I call it the Section 28 of pensions. Section 28 was on the statute book for 15 years. This pensions version of Section 28, saying you're not an equal family, has been on the statute book for 18 years and will still be there in January. So we still need a bill next year, hopefully, to get rid of it permanently.
We need to get rid of it permanently, but at least as far as the practical consequences are concerned, which I repeat, can run to tens of thousands of pounds, we have solved the problem. Thanks to you, Rob Wintemute. Thank you for doing that. And thank you for joining us here today.
Thank you.
Bye-bye.
Bye-bye.